Number 6. Before us to the question comma which was before the two quotes below comma, namely as what was the effect of the omission of the landlady comma who claimed to require the house for her personal occupation and for that of her son comma upon to her case as held by the rent controller, or whether the learned judge in the High Court was right in holding otherwise. Full stop. Para Mr. Abdul Wahab, learned counsel for the petitioner, presented a vigorous argument in support of the above plea, but despite his enthusiasm for it, we we are not persuaded to agree with him. Full stop. We note that subsection 2 of section 15 of the Sindh Rent Ordinance, 1979, provides that the rent controller can direct the tenant to put the landlord in possession of the premises if he is satisfied, inter alia, that the landlord requires the premises in good faith for his own occupation or for the occupation of any of his children. Full stop. Full stop. No limitations are prescribed in the law to fetter the description slash discretion of the rent controller in this connection, nor is there any prescription with regard to the nature of the evidence which must be produced before him to satisfy him on this point. Full stop. His satisfaction is to rest on the material placed before him by the parties, and no conditions are laid down as to the exact nature of the evidence which must be produced before him so that he can be satisfied. Full stop. In this case, the son-in-law of the lady, semicolon, as he was living in Karachi, it was convenient for him to appear before the rent controller, rather than the landlady who was residing at Quetta. Full stop. As for the son, though living at Karachi, he was working in the National Construction Company, while the son-in-law of the landlady, being a retired person, had more time at his disposal. Full stop. Even otherwise, he too is a member of the family, having knowledge of all the relevant facts. Full stop. Moreover, the facts deposed by him, namely, that the landlady was the owner of the premises, semicolon, that she was presently living at Quetta, semicolon, and that she now wanted to shift to Karachi where her other members of her family were residing, semicolon, that her son was employed at Karachi and had no separate accommodation but was living in his house, semicolon, that the landlady too had no other house in Karachi, were not seriously contested. Full stop. In these circumstances, we cannot appreciate why the rent controller was not satisfied about the bona fide need of the landlady to to get possession of her house, and the learned judge in the High Court was, therefore, fully justified in setting aside the erroneous view taken on this point by the rent controller. Full stop. In fact, this court has, in several cases held that the order of eviction of a tenant cannot be challenged on the ground of failure of the child to appear in court, for whose benefit the landlord is seeking eviction of the tenant, and his omission to appear before the rent controller to depose about the said need is not fatal. Full stop. The upshot is that there is no force in these petitions, which are, accordingly dismissed. Full stop.